Okay, Una is also here. So I suppose that Dushanka will come in a second.
Yes, Dushanka and Jelena are a little bit late due to traffic.
Due to traffic, but
Here she is, yes.
Dushanka is here. Okay, great. So Dushanka is here. And I suppose that Jelena will join us very, very soon. So let's start. And then when Jelena joins us, I suppose we will go to today's topic. But let's briefly go over the topic that we discussed last time. So as you know, we first talked about gender perspective in international public law in general. And then we went into the very specific branches of international public law to see how they do they have an overlook and also inclusion of gender equality in the laws and policies which govern that area. And just to remind you very briefly, you first discussed the international environmental law and climate change as an effect on gender equality, and we will discuss that issue much more within the course on human rights. And last time we discussed international humanitarian law. And is there anyone who would like just to repeat very briefly what we said for international humanitarian law? And I see that Dushanka, she has a cat. I have a dog here, so we also have Animal Planet together. But it will feel a better energy that we have in the group. So who would like to start? Dushanka, you wanted to say something.
Yeah, I have to say that I have two cats, and probably they will join us quite briefly. Yeah, but I hope that you hear me well. I know that sometimes I have trouble with the internet. Regarding the last week's lesson, we talked about Geneva's Convention as well as Hague Convention that are, in a way, the leading parts of international humanitarian law. And I'm sorry. And
what we said, Dushanka, exactly. So we first of all discussed the existing, let's say, we cannot say legislation because they are not laws, but they are conventions. So treaty laws that we have governing the international humanitarian law. And what we said from the perspective of women and girls.
For most of the conventions, they are not mentioned, and if they're mentioned as mothers or as victims of gender-based violence. So they're not seen as a person as such, and they are. I think that they're mentioned only in civilian Geneva Convention. Maybe I'm wrong, and there are some provisions, but most of the provisions that are there are in the additional protocols, so they are not in the first four conventions.
Yes, in a way, what we said, we discussed that, first of all, there is no systematic approach to women and girls, that we have two streams, two areas in which women and girls are, let's say, covered. The first one is, as Dushanka said, mothers, pregnant women and mothers, but not mothers in general, mostly the mothers of small children up to 7 years, mostly. And we also said that we have women in relation to gender-based violence, but also with a language which is a little bit archaic. which is not, let's say, the wording which we have in international human rights law conventions. And also what we mentioned is that we still have the implementation of international human rights law, even if when we have armed conflict, either we have internal or international armed conflict, which means that international human rights law very well supplements those provisions and also provides greater protection to women and girls. Today, we will go into another branch of international law, which is basically very much connected with IHL. Why? Because usually when we speak about the violations of IHL, we speak about the implementation of international criminal law. And I will now put my presentation. You will just confirm that you can see it. Is it okay?
It's okay.
It's okay, great. So let me, okay. And in order also to follow the presentation, I'm not seeing you, but please, as previously, if you want to jump in, to ask something, to say something, just put a microphone, okay? So when we discuss about the international criminal law and gender, I'm pretty sure that you're more familiar with this branch of law, especially if you are not a lawyer, because we, in international arena, in everyday news, we basically read a lot of articles on international criminal law. And why international law is so important? It is important because it provides mechanisms for holding individuals accountable for heinous crimes that we have in international relations. When I say individuals accountable, it means that when we have a violation of international humanitarian law, we speak about the responsibility on the part of the state, which is a part of civil obligations. But when we speak about the criminal responsibility can be only individual. And it means that international criminal law defines, first of all, give us the list of these heinous crimes. Those are the crimes that affect the whole international community, which is of concern of whole international community, and basically gives standing to prosecute those who committed those crimes. And we have 4 core international human rights crimes. This is genocide. These are crimes against humanity. These are war crimes. And finally, a crime against peace or aggression. When it comes to the understanding of how gender is important or specific in this branch of law, it is really important to understand that conflict-related harm that we basically discussed last time is deeply shaped by gender roles. And this is what we've seen on many examples that we mentioned. And here, not only the gender roles, but also the stereotypes and prejudices, and also in systemic inequalities which exist within societies, also shape that reality. And it is also important that when we include this gender analysis, we are not looking only through a, let's say, monolithic group of women and girls, but we also take into account other realities which can also shape what they went through, which means the age of women, their gender expression, then sexual orientation, but also how it also reflects to something that we mentioned last time, and this is how it reflects to men and boys. In a way, when we speak about the evolution of gender, of this component, we have to say that, like in many other branches of international public law, gender crimes were overlooked. They were prosecuted only as incidental. And when I say incidental, I mean when, for example, the crime was primarily about different crimes, and then, for example, some gender perspective was included into those crimes which were committed. And it is also important to understand that even when in the evolution of legislation itself, of conventions which were relevant for this area of law, it was important to understand that we had also an evolution of understanding and inclusion of crimes which have gender perspective. And from that point, maybe you know that that we have a long discussion within the international community to have some international courts which can basically prosecute for these crimes. And usually we speak that a very important turning point in this area was basically the trial which was conducted after the Second World War. A very famous Nuremberg trial, Tokyo trial. But the problem is that there were not specific crimes which were gender related. And a very important change in the perspective of looking over the gender crimes was when we got the establishment of two ad hoc tribunals. When I say ad hoc, it means not a permanent criminal tribunal, which will be responsible to prosecute for all crimes which goes within these four that I just mentioned. But basically, it means that we have one specific armed conflict and also the time frame within which we will discuss crimes which were committed. And for that, we have ICTY. This is the International Tribunal, which was established for former Yugoslavia. And also we have ICTR, which was the International Criminal Tribunal, which was established for Rwanda. And what is extremely important from this perspective is to understand that both of these tribunals not only included and enlisted some crimes within their statutes, which have this gender perspective, but also they recognized and they prosecuted for those crimes, which means that now we have some very solid jurisprudence which recognizes very specific gender-related crimes, such as rape, such as sexual slavery, and such as forced pregnancy. This advancement or the recognition within the international community came further with the Rome Statute. The Rome Statute is the one that established the ICC, or the International Criminal Court, which is based in The Hague. So basically, this is the first permanent criminal court that we have that deals with this core for international crimes that I mentioned. So to mention it once again, this is genocide, crimes against humanity, war crimes, and the one that was really very difficult to define, and the states agree about the definition, which was the crime of aggression. When we see the most important crime, which goes with gender, which is a sexual violence, and sexual violence is an international crime. I already mentioned that Nuremberg and Tokyo tribunals did not pay attention to this crime, so they were not recognized, and we don't have any reference to any trial which included this perspective, although we know, according to some historical sources, that sexual violence was also a very powerful tool which was used during the Second World War. Well, what I said is that the International Criminal Court and these two ad hoc tribunals, that they included special provisions on some gender-related crimes, and here primarily I mean about sexual violence crimes. And the first conviction of an individual for specifically for rape, which was recognized in a way how it was performed as crime against humanity and also as genocide, was in the International Criminal Tribunal for Rwanda for Jean-Paul Akayesu, and this is why we say that this decision in this case is really a very significant turning point to this. And we will come a little bit later to some specific, very specific cases. When it comes to the key legal framework in this area, I already told you that we have the statutes of these two ad hoc tribunals and the Rome Statute of the ICC. The Rome Statute do not define only rape, but it also defines sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, which is also very important. And we know that we have many cases which were identified, for example, on the part of the CEDAW committee. This is the Committee on Elimination of All Forms of Discrimination Against Women, that even during the peace, not only in some armed conflicts, we have the cases of enforced sterilization. And usually we have two groups which were identified as those exposed to enforced sterilization, such as Roma women and also women with disabilities. But we also have it from the perspective of international criminal law, when these crimes are committed in a more systematic way. And then they can be recognized as primarily crimes against humanity if we have that systemic approach in conducting those crimes, or on the other side, it can be a war crime if it was committed within the framework of the international humanitarian law during an armed conflict. What is especially important is that if you have any of these crimes which are recognized in the Rome Statute, then we can also speak about a very specific form of persecution, which is called gender persecution. And the gender persecution means that we are targeting individuals based on gender, or based on gender norms. And this is a very separate crime. So gender persecution. And gender persecution is usually recognized as a crime against humanity. And this is how it is enlisted in also the elements of crimes, which is a supporting document to the Rome Statute. And it's a very important part or document, because it guides prosecutors in establishing intent and evidence. Because as you can know, we can have a definition of a crime. So this is one point. Can we refer and can we use specific crime, and can we claim that the crime was committed in some specific context? And then another issue is the issue of establishment or proving that elements exist. And the evidence part is also the trickiest part when we speak about the international criminal law itself. Now I will go with more specific details about the Rome Statute. And I mentioned this core for international crimes when it comes to the genocide. And you know that the genocide is a very important crime, which was recognized also in one convention, which was adopted after the Second World War. And the definition that you see here in front of you was basically taken from that convention, which was adopted in 1948. What we see here in this Article 6, we see acts which come together, which can form basically the genocide. And here you see different acts, but it is all important that acts are not standing alone. They have to be they have to be accompanied by a specific intent, genocidal intent. And what we see from Article 6 is that intent is to destroy in whole or in part a national, ethnic, racial or religious group as such. So what we see here is that sex or gender was not recognized within the meaning of the Rome Statute, and especially Article 6. However, what we see from the acts is that some acts are very much oriented towards women. And we spoke about it a little bit last time. So as acts, we have killing of members of a specific group. So one of these groups that were enlisted, then causing serious bodily or mental harm to members of the group. And then we have something which is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And then we come for a very specific act, which is basically gender perspective. And this is imposing measures intended to prevent births within the group. And then here, for example, here enforced pregnancies or maybe sterilization can come as a way of performing that act. And finally, this is the last act is forcibly transferring children of the group to another group. So basically, this D is very specific, as this is as it is gender oriented. But what we see with this specific intent, which basically recognizes four grounds for this treatment, such as national, ethnic, racial, and religious, that it usually is a genocide if we have intersectionality approach. In other words, if, for example, we are targeting specific women, but women who have either specific nationality, ethnicity, they're coming from a different racial group, or they belong to certain religious groups, to certain religion. What is also important is that what we said about the core crime of genocide is that acts of sexual, reproductive, and other gender-based violence can be relevant to the acts of genocide. And what is important is that also one perspective that needs to be taken into account is that male and female members of the group can be targeted for genocidal killings, sometimes differently. And some of these issues we also discussed last time. But it is also important that in some cultures, women may be devaluated for not being able to bear children, where, for example, their word derives from the reproductive capacities. And this is something which exists in almost all societies. This is when we speak about gender equality, we usually target some measures basically to increase reproductive capabilities of women. But it can also be alternatively, if they're targeted because of their ability to perpetuate a group, which can also be an example. And what is also important is that we also said, if you remember, and I will go further, when we read these acts, for example, this B, causing serious bodily or mental harm to members of the group, we don't see this gender perspective immediately. So it's not so expressly stated. But also we need to take into account that to cause someone very harsh harm, either physical or psychological, can also be considered to be an act of genocide. And here we can also have, for example, rape, and some other forms of sexual violence, which is also important. And they can, from that perspective, whatever is inflicted to that specific women can be also considered to be a genocide. So we see some very direct elements of let's say, gender perspective, but we also see that in practice, what is going on can be attributed to elements of genocide. What is also important is that I mentioned already that this D element is the most visible or relevant when we speak about this gender perspective. And I also mentioned forced sterilization, but it can also be the act of sexual mutilation, forced birth control, forced separation based on gender, sometimes even prohibition of marriages, which as a result comes to the prevention of birth. And also it can be the different forms of threats, which are done by purpose, and to with the purpose to inflict trauma by some acts which are extremely violent, and they ensure that victim does not procreate. So everything of this was also visible in practice thus far, even if maybe we didn't have a recognition of genocide in these specific cases. Crimes against humanity are the most common when we speak about gender perspective. So remember that Article 7 of the Rome Statute is in that regard extremely important. Why? Because many acts are very gender specific. And we will now see those elements. First of all, when we define what are the crimes against humanity, we see that we have some specific acts which are committed, and this is a very a non-avoidable element of definition of crimes against humanity. Then when we have widespread or systematic attack, which was directed against any civilian population with knowledge of the attack. And then we have this G point, which expressly says rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. So what is important with this provision is that we have the most common ways of performing gender-based violence, but also this is not exclusive list, because it's also open to some forms of sexual violence which are what is said of comparable gravity and which can appear in practice, which is a very important and good approach in defining crimes. What is especially important is that here .h also speak about the persecution itself. And it says that the persecution exists when we have identifiable group or collectivity, which is based on several grounds of discrimination, such as political, racial, national, ethnic, cultural, religious, or gender group. So what we see compared with genocide is that we have gender here. And what is important is that also the list of these grounds is not exclusive, because we also see in the language, in the wording of Article 7, that we have some other grounds that are universally recognized as impermissible under international law, and then in connection with any act which were already mentioned above. So basically it means that sometimes, for example, the language can also be the ground, it can also be disability, so that can be also other grounds of discrimination, not only those who are enlisted here, which can be also important, especially from the perspective of whom we protect, as also gender sometimes can be only related in national legislation to gender itself, but it can also encompass sexual orientation, gender identity, gender expression, and so on and so forth. And what is also important in order to understand who is gender, and here we come to the definition which is given in a Rome statute, we see that the term gender refers to the two sexes, male and female, within the context of society. So it does not indicate, for example, what I said, sexual orientation, gender identity, gender expression, but it relates to two sexes, male and female, and also to not only their biological differences, but also to the difference assigned to their specific roles which they have in a society. When it comes to war crimes, Article 8 of the Rome Statute defines what are war crimes. And what we see is basically the reference to Geneva Conventions that we mentioned. So if we have grave breaches of Geneva Conventions, then we can have war crimes. And what is also more specifically enlisted here is that like genocide and crimes against humanity, acts of sexual, reproductive, and other gender-based violence are equally relevant to war crimes. Basically, what is important here to understand is that everything that we've seen that have this gender perspective within in Geneva Conventions itself basically can be recognized as war crimes. So all these gender-based provisions which relate to gender-based violence and also to women and mothers can be a part of war crimes. When it comes to sexual gender-based violence, then it is important that usually the form of violence, what we know that violence can have different forms. And violence can be in the form of physical violence, of psychological violence. It can be economic violence. It can be digital violence that we also discussed and we will discuss many times. However, sexual violence is a very specific violence, and usually when it comes to the definition of international crimes, then we speak about sexual violence and infliction of violence over the sexuality of a specific person. And then we speak about rape, about sexual slavery, about forms such as forced marriage, about trafficking in human beings, and here in women and girls, and some acts which can be considered to be enforced pregnancy or sterilization. And what is important is that they can be prosecuted within all these three groups that we just mentioned. They can be prosecuted as war crimes. They can be crimes against humanity, or that can be even genocide if all elements are met. However, it is important to understand that when we speak about the crime of aggression, then we don't have any specific gender perspective, bearing in mind how how this act is defined. And when we go further and see these three crimes that I just mentioned, usually the elements will go primarily, or the elements of crime which exist in specific case will primarily be recognized as crimes against humanity. Whatever the crime that is recognized, these are heinous crimes, and they all reflect either the harm to body, to someone's physical integrity, but also they're usually within the way of how the crimes were performed. They have also the elements of structural domination. This is, for example, something that we today very clearly see in Afghanistan. Is there any question so far for what I said so far? Any reaction to this very basically very basic introduction of how much gender perspective is included in international criminal law itself?
Professor Dar Hadi ma'am.
Saiful, you want to say something?
And I already said Dar Hadi ma'am.
Oh, great. I'm happy. Okay, so any other comment or maybe question to what we said so far? Okay, so if no, we will go to the relevant case law. So when it comes to the relevant case law, you remember that I already mentioned Akayesu case, but I will also mention some other cases which came from all these three jurisdictions that we have today. So first important case that we will discuss is a case which was decided by ICTY, and it was Kunarat's case. In this case, rape and enslavement were recognized as crimes against humanity. In Akayesu case, the case that was decided by the Rwanda Tribunal, again, rape was recognized, and it was recognized as a component of genocide. In Ntaganda case decided by the ICC, we had sexual slavery and rape of girl soldiers, and we will discuss more about this case. In Ongwen case, we had forced marriage, forced pregnancy, and gendered harms within armed groups. So in both of these cases, ICC cases, we had that sexual slavery, rape, and forced marriage were discussed within the war crimes. And in Al Hassan case, we had the recognition of crimes against humanity, where we had different forms of gender-based violence, which also showed that structural inequality that I just mentioned, which can have also a very significant influence, and also they can inflict very significant harm to women and girls, which are supported by very coercive social norms within society itself. The first case, and here you see this this person. This is prosecutor versus Konrad's case. This case was, and what you've seen is that the majority of cases include rape and some forms of sexual violations, such as sexual enslavement. This is exactly the case decided in prosecutor versus Konrad's. Also, torture here was used as an element of coercion, and it was inflicted on Bosnian Muslim women and girls during one specific conflict during the war in Bosnia and Herzegovina in Foča. And you see the time when these crimes were committed. So it was 92 and 93, so the mid of this conflict. And what is important is that women, they were held in different detention centers and some private apartments, and they were subjected to repeated sexual violence. And what is important is that in this case, it was the first recognition of sexual enslavement, and which also, let's say, clarified the elements of this crime. And also established rape as a crimes against humanity, which were based on different forms of enslavement, imprisonment, and also torture. We had not only Konrad's, we also had other two men who were accused, Kovac and Vukovic, but Konrad's was this case is famous according to his name because he was the one who was the mostly responsible for these crimes, and he also got the harshest sentence. In his case, he got 28 years of imprisonment, while Kovac got 20 and Vukovic 12 years of imprisonment. So let's try to watch this video. I hope that I will be able to produce it. So just give me a sec. And I hope that you can also hear well the sound. So let me share it. Okay, you will just confirm if you can hear the voice.
It's a watershed in international criminal law.
We can hear
It has been more than courageous in many.
Now we are not hearing.
Yes, now we can't hear it.
Now you can hear. Okay, great. Because we needed to do everything again, because we, you know, that we didn't have renewed license for WebEx. We'll start it from the beginning.
It's a watershed in international criminal law. The tribunal has been more than courageous in many fronts. And I believe that one of those fronts is the serious and diligent attention that's paid to questions of sexual violence and crimes of sexual violence. There's been more jurisprudence out of our tribunal in 5 years than in the past 500 years from international criminal courts.
Until the ICTY, until rape was listed as a crime against humanity, it had been ignored in all international instruments. What the tribunal has done, I believe, first just by listing rape as a crime against humanity, but secondly by prosecuting it and by developing the jurisprudence of sexual violence, is that the leaders of these conflicts are now put on notice that the rules have changed. That's an important development. It's the development that has been picked up by the ICC, and now you can't imagine an international tribunal or a mixed tribunal without sexual violence being prosecuted.
And we're talking about sexual violence that occurred during the armed conflict in Yugoslavia, but that might have been committed against men and women. It's a weapon. It's because it goes to the very psyche of the person. It goes to a physical sense of the person. It goes to a social sense of the person.
Zgazio mi je ponos. Više ne mogu nikad sebi da dođem, da budem žena kao što sam bila.
It's a very adequate manner in which the person somehow feels that they've experienced a death and yet are condemned to continue to live.
They came, they were very willing, and even during the time that we were giving evidence, that they were determined to tell the truth because they wanted justice to take its course. The courtroom opportunity gave them an opportunity also to look at their assailants in the eye. So we did have some courageous witnesses.
On je, pošto je završio, mislim na silovanje, pošto je znači završio silovanje, sjeo je i zapalio cigaretu. Rekao je da bi on možda mogao i više, i mnogo toga više. Međutim, da sam otprilike još neke njegove čijeke, za sada neće.
I believe the women have contributed to reconciliation. Now, whether it's a conviction for rape, what that adds, I think that it gives a strength to the women who've testified, a vindication of their suffering. I know that it gave incredible strength to women all over the world. I share with witnesses in saying it is my hope that there will be differences in the way war is waged because of witnesses testifying before this tribunal. I don't know that yet. They don't know that yet. But one of the driving motivations that brings witnesses these difficult steps to talk to this tribunal is their hope that if they do this now, then nobody or people in the future won't have to suffer like they've suffered.
Okay, folks, so what we've seen in this film is not only Kunadak's case. He was also mentioned. Or what we've seen is that one witness also testified from that specific trial, but also it's some kind of reflection on the jurisprudence of the ICTY in relation to some gender-based crimes. So is there any reaction to what you heard? Anyone would like to maybe say what we've seen?
I like how the judges were all women and talking about the situation in question. And throughout the class, I again and again am, it's wrong to say amazed, but it's very interesting how much of practice we used from in the tribunal for Yugoslavia and Rwanda, but especially Yugoslavia because it's closer to us, and how many things have then stayed as a legacy after it.
Absolutely. And what they said at the end? What is the expectation? Is anyone who maybe paid attention to that? Do they have high expectations from what witnesses testified?
Well, it was the expectation for not to be as hard as it was for them. So the crime will exist. for sure, but it will be known that that's forbidden and it can be prosecuted. So
absolutely. And maybe also some other reflection to what you've heard, where we can also notice either the brutality of those crimes, or we can at least guess the harm that was inflicted to those victims. Any reaction to the witness who testified in Kunarat's case? A witness who was the age of his daughter, what he did after he committed a crime?
If I can say, I think that all witnesses were really brave to stand with their identity visible or without their identity visible, because this is really a harsh truth that happened to them, and to have an easy way because you are the age of his daughter. It's really just the double trauma.
Mm-hmm. So, yeah, absolutely, Dushenka, you're right in what he said. He took the cigarette to enjoy, to pleasure the moment of being like macho, in this case. And we still see, after so many years that she testified about this event, how she was, let's say, what was her reaction to what was committed to her, what she felt during that moment. So it really shows the brutality and very significant harm inflicted to all these victims. So why, these gender-related crimes, sexual-related crimes are so specific in that regard.
Can I ask you something?
Sure.
Did they use the screening rooms when they testified?
Yes, you saw that also the sound was different. You noticed that. I don't know if you can see a good sound, but of course, measures of protection of survivors is a very important part of testifying before criminal courts. Yes, exactly. It's a good question. Thank you for that. So what we've seen in this film is not only, as I said, prosecutor versus Kunarat's case, but also we've seen this development in that we had a silence of international criminal law, and then suddenly we had crimes not only recognized in the statute itself, but also in practice. And here we have this Akayesu case that I already mentioned. In this case, we have a local mayor. He was in Rwanda, and what he did, he facilitated and encouraged. So not committed by himself, but encouraged and facilitated very widespread rape and sexual violence. And I suppose that you know a little bit about this genocide, which happened in 94 and lasted for a very short period of time, 90 days. So in this period, this rape and sexual violence have happened. And what is also interesting as effects of the case, that he knew women and girls were being raped. So he was, of course, that he was aware, but he didn't fail to stop or punish those who did it. And he also, and by that, he encouraged and facilitated this crime. And what is important to say about this case is that this was the first case that recognized rape as an act of genocide, because we spoke about these crimes, but within the crimes against humanity scheme. And here it was recognized as a genocide, which is a very, very important development. And what was established by the tribunal in this case is that sexual violence can be used to destroy a protected group, which before that it was questionable. And it also is important because the definition of rape was also broadened in a way to include different coercive acts as acts of rape. So this is why basically the practice is so much important, because it gives us not only the recognition of elements which are included in the statutes itself, but also how we defined whether and how we identify them, if they exist and not, and what we include in that range of different coercive acts which can be recognized as rape. So let's again watch one short video about this case. And sorry that I will have to do it on this way. So let me share it. Can you see it? Yes?
Yes.
Great. Thank you for confirmation.
In the spring and summer of 1994, an ethnic cleansing campaign in Rwanda left 800,000 people dead, even while United Nations peacekeepers were on the ground and the rest of the world did virtually nothing to stop it. Toward the end of a civil war, Rwanda's government, then run by its ethnic majority, the Hutus, systematically murdered 70% of the country's ethnic minority, the Tutsis. As the toll of the carnage became clear, human rights groups successfully pressured the United Nations to convene the first ever International Tribunal for Genocide in history. Between 1998 and 2012, the International Criminal Tribunal for Rwanda convicted 62 individuals for the genocide and other serious war crimes. Part of the story rarely told involves the brutal mass rapes of an estimated 250,000 women, men, and children during the genocide, and the world's first prosecution of rape as a war crime. A new documentary, The Uncondemned, sheds light on this atrocity and the struggle to bring justice for the rape survivors. Journalist Michelle Mitchell directed The Uncondemned, which refers to the perpetrators of mass rape not held accountable until the landmark prosecution.
International Criminal Tribunal.
The film revisits the events and the case that would change international law.
Why is this an important story to tell today in 2016? Rape has been a crime of war since 1919, but it took almost 80 years for rape to be prosecuted for the first time. And the reasons why they finally prosecuted continue on to this day. And those include it happens in every conflict around the world with all religions, and it's almost never taken as seriously as other crimes of war. It's a vital story now because as we are sitting here and talking, we know that it's going on in Syria, in Iraq, by ISIS. We know that Boko Haram is doing it, South Sudan. I can name any number of places where this is happening as we're having this conversation.
Are there complexities about sexual violence in times of war that you think are often misunderstood?
One thing that I have consistently heard over the last 3 years as we were making this film is that, oh, well, rape is just something that happens in war, and it's always happened. The act of sexual violence will rip apart a family and a community, and by virtue of that, a society for several generations. And it's not just the shame that happens. A lot of times you are physically incapacitated after that incredibly violent act.
The Uncondemned focuses on the case brought against a mayor, Jean-Paul Akayezu, who was charged with genocide and crimes against humanity for ordering mass murders and rapes that occurred in his township, Taba. Mitchell interviewed rape survivors as well as the prosecutors and aid workers who took up their cause.
They would say, we begged to be killed after the rapes. We'd say, please kill us, kill us. And a lot of the Interahamwe, the Hutu militias, would say, no, we're going to leave you alive so that you will die of sadness. And that's what these women said, that we are dying of sadness now.
The trial is...
An American-led legal team convinced a panel of UN judges that Akayezu had used mass rape as a form of torture. Pierre Prosper, then a Los Angeles assistant district attorney, was one of the prosecutors.
Can you talk about that moment when you realized that prosecuting rape was essential to Akayesu's case?
It really became critical for us in the Akayesu case when one witness told us about an event where women were being taken back to the back of the city hall and systematically distributed and violated, and that Akayesu was there. It became clear to us that this was really the scheme, part of the genocide, part of the torture, part of the destruction of the fabric of the society. So it was a designed plan to diminish a population.
With no legal precedents, the under-resourced and underfunded legal team had the difficult job of making the case that mass rapes are just as detrimental as murders during genocide. Once the trial began in 1997, there were high expectations.
We had the pressure coming out of the West, whether it be New York, the United Nations, or Western governments, looking at us and saying, are you going to win? Because they needed us to win in order to send a message to the international community that there will be accountability for genocide.
As the film recounts, Prosper and the legal team convinced 3 Rwandan survivors to step forward and testify against Akayezu in court, sharing that many women in their town were forced to endure multiple acts of sexual violence commissioned by him.
y'abantu bo mu bindi bihugu bo mu rwego rw'isi ngira ngo icyo cyaha ngikoze isoni.
I remember putting witnesses on the stand, and you leave at the end of the day just emotionally drained and say to yourself, wow, I have just now heard the worst that I've ever heard in my life. The next day, the next witness comes on, and then you say, no, today is the worst. And it was like that throughout the entire process.
Akayesu's conviction and the concept of rape as a war crime, how did it change the game?
It did a couple of very important things. It set the precedent. The whole reason why we can prosecute rape as a crime against humanity, crime of war, and as a crime of genocide is because of the Akayesu verdicts. And the other thing it did, which was really interesting, is that it took gender out of it. And that's incredibly important because men are raped in conflict as well.
After a 20-month trial in Arusha, Tanzania, the Rwanda War Crimes Tribunal sentenced Akayezu to life in prison. In the years after his precedent-setting case, international tribunals showed greater resolve in recognizing wartime rapes, such as the tribunals that held Serbs accountable for their treatment of Bosnians in the former Yugoslavia. More recently, crimes of mass rapes were prosecuted by tribunals following atrocities in Sierra Leone and in the Democratic Republic of Congo. But Prosper believes even today, the global community could be more responsive in conflicts like South Sudan.
I think we've lost a bit of our footing. And I actually think what happened is that once the Permanent International Criminal Court was created, people looked at that as, oh, we've arrived. And the politicians around the world say, we've done our job, there's this court, we need not focus on these issues. It creates this gap, a gap of inaction. So I think the international community needs to wake up. The governments need to wake up and realize that their responsibility continues.
A responsibility that international reporting keeps in the spotlight.
The men and women of the press corps who covered what happened in Bosnia and also in Rwanda and covered the sexual violence and wrote about it and put it on television and kept it in the public eye, that created interest on the part of the public, who then wrote letters to the tribunals saying, we want you to prosecute this. We're going to be watching. It goes all the way around to the fact that the public got involved and demanded of leaders, take this seriously, do something. So if it worked then, it can work now.
They can create
any character you want.
real life, fantasy, sci-fi, even anime.
Okay, sorry for this. So is there any reaction to this film that we've seen?
Maybe I can say.
Yelena, please go ahead.
Yeah, first of all, it's really stressful to hear and listen to all of this. It has made really a big impression on me. Second of all, I picked up 2 things. First is how it took gender out of the picture, because they got to a conclusion that males were also raped. And another thing is at the very end about the media and media reporting about those cases, and actually the power of the public that influenced all the process before the court. So those 2 things were interesting to hear that I didn't know, and everything else was really, really, I don't know how to say, overwhelming and hard.
Excellent observations, and thank you for sharing. This is a very hard topic, and even when we speak about IHL, we don't have the test. We don't have the proofs of different, or maybe at least to hear what survivors testified in some specific cases. But now, when we hear, and for us, it's harsh, even if we just see the reaction of interlocutors in this documentary. But you also seen this undocumented documentary, and I also advise you, if I have time and you're interested in topic, to also to watch this film. Any other reaction to apart from Yelena's?
I can say.
Yes.
Go ahead. Someone was before me.
Go ahead, Ksenia.
Ksenia, please. Yes, go ahead.
Unfortunately, I've seen a few documentaries regarding this topic, especially in the Balkans region and the war that happened in Bosnia. They mention it in this video as well, and I always thought, and I always heard from people who were witnesses of these awful things, that this kind of torture is the most degrading one, that it's even worse than murder, and that's what that woman said in the video. So the topic of rape is, for me personally, the most disturbing one, and this was very hard to see. But it is important to be kind of exposed to this horrific stuff, because that's the only way we can prevent it in the future. But it was very respectfully put together in the video and very informative. So yeah,
Thank you, Ksenia, so much. And what I said, they are dying from sadness.
Yeah, that was the worst thing. When I heard that, I mean, I read about it, the victims of rape, not only related to war, but generally, it really scars the person in ways that you cannot imagine. And, I mean, that's the worst part for me. When I hear it, it's giving me, physical, like, discomfort. So yeah. But as I said, we should really be exposed to this information to be educated and to prevent it, hopefully, in the future.
Thank you so much. And who also wanted to say something?
Yes, I just wanted to add that in both cases, but in Rwanda they said that rape and sexual violence was not just the thing that was happening because the war is happening in that region, but it's the way of war. It's a tactical war, and somebody decided and give the order to rape and to commit sexual violence. And what Jelena said about taking the gender out of it, I didn't like that point of view. I don't think you can take the gender out of it. Of course, men are raped too, but it's also different. For example, because women get pregnant, and the stigma for the children that are born or not born is also stigmatized. So I don't think it's the same. But if it was same, you cannot take gender out of that topic.
Thank you so much, Ona, for saying that, because when you see the scholars dealing with these cases, they don't see that gender was taken from this case. Because although is true, and we should also pay attention to all survivors of rape, and they can be, as we seen in Rwanda's case, men and women and girls and boys. At the same time, much more women were they suffered from rape and were exposed to rape. So in that kind, you have still many scholars saying that this is also a victory of primarily women and girls who were recognized as victims in this case. When I try to be very careful using terms victim and survivor. But when I say victim, I mean in a legal term, survivor more in a societal term. So Yes, you're absolutely right, and this is something that we can criticize. But basically, that was the opinion of a person who believed that it's also a first time that we very clearly seen in international community that also men and boys can be victims of rape. You will also see in my presentation some, I'm sorry for this, it's the wrong one. You will also see some other films, but as I know that it's too much for you to watch all of these films, so you will see, I will post my presentation tonight. So if you just feel comfortable to see other videos as well, do it whenever you are in a mood to do so. But the next case that I wanted to share with you is Natanganda. It's always hard for me to pronounce the name, the Natanganda case before the ICC. He was a commander in Democratic Republic of Congo, the country that was mentioned by some of the interlocutors in this video that we've just seen. And he was committed, basically, he was prosecuted for sexual slavery and rape, in his case against child soldiers, and within his own armed group, which is also amazing. But there was not, that was the primary indictment, but also many numerous war crimes against civilians, including murder and displacement. And what is important is that in this case, we also had a conviction of sexual slavery and rape for the first time by ICC now, or International Criminal Court. And it can also, it's a very important development in understanding that crime can be committed not only against a group which is outside of the scope of commanding, but also within the same armed group, and not only against civilians. And it was also a very important development in that kind, just to give us more elements of definition of these crimes. And he got 30 years of imprisonment for crimes that he committed. In another case, we also have Dominic Ongwen. He was a commander from Uganda, and he was forced for forced marriage, for forced pregnancy, for enslavement, rape, and sexual slavery, including crimes against women abducted by this Lord's Resistant Army that he commanded. And the significance of this case is that was the first case where forced marriage was recognized as a separate crime, and also where the prosecutors and then the judgment itself gave a very good analysis of forced pregnancy. And what was also very significant in this case is that again, within the armed group structures, we can have the recognition of these crimes that we are discussing today. Especially important case is Al Hassan case. This case basically is extremely important as it also show different perspective, different gender perspective in this case, because we here had the armed group which imposed a system of gender discriminatory rules which are very and control of women to what they are dressing, their movement, marriage, and behavior. What you can recognize, for example, is many elements that exist in Afghanistan at the moment. And what is important is that here we had the gender persecution recognized as an act that was committed, and I will just remind you that gender persecution is recognized as a crime against humanity, which it is very important that here, what the court found is, and it was very well let's say very well defined by prosecutor itself, is that that systemic gender oppression that women went through basically can be considered to be persecution. And this case is really very significant landmark case in showing that structural inequalities, domination of one sex over another, and also coercive social norms can amount to crimes against humanity. Here we have, and this case is a very good basis for defining what is happening in Afghanistan at the moment. As you know, that from 2021, when Taliban's again got a power in Afghanistan, at the first time they claimed that they will pay so much attention to gender equality. Unfortunately, it did not happen. And in the meantime, for the past 4 years, they adopted some of around 250 edicts. And I think that around 157 exactly, so around 160, they impose very clear and very harsh restrictions on women and girls. And I don't know if you read more about the situation in Afghanistan, but those restrictions concern the right to education, the right to work, freedom of movement, also the way of how women are dressed. Then they are exposed to arbitrary detention, especially if they in a way demonstrate for their rights. So the freedom of assembly, the freedom of opinion, and expression of that opinion is restricted in many ways. So we can say that today that this systemic approach of coercive elements which exist in a society, within society itself, leads to erasure of women and girls in public life. So here the whole question is whether this amount of edicts which are inflicted in all areas of social, basically, and public life, can be considered only as gender-based persecution. And you have 2 films that you can watch later. Here we also have the first woman prosecutor before the ICC, and also what she says about her role. And maybe if you have time, we can return to her, to this video, and maybe to, in a way, reassess to what she said. But when it comes to gender persecution, it is important, as I mentioned, that it was formally introduced in the Rome Statute. And what we've seen is that elements of gender persecution exist when the crimes are inflicted against any identifiable group or collectivity on, among others, gender grounds. So it's a very good standing to recognize that we have gender persecution. Also, you remember that we said how the gender was defined in Article 7.3 of the Rome Statute. We've seen that it has a little bit limited definition. It does not have a biological element itself only, but it also have the social construction of how the society understands the role of men and women in a society. And it's very important because what we've seen in Al-Hassani case, but also what we see in Afghanistan today, we will not be able to identify persecution as gender one when we have this very systemic oppression in a society and structural inequality which leads to oppression of one gender over another, that we don't have this broader definition of gender itself. And of course, it is good that we have this definition, because usually we use the term sex when we refer only to biological differences, and term gender when we also have social perspective included in a definition. What is extremely important is that we've seen the development of these ad hoc tribunals and also their statutes. and we've seen that they recognize rape and other sexual forms of gender-based violence within its statute, but we didn't have gender persecution as defined in this statute. So we have to acknowledge that the Rome Statute was the first international treaty to explicitly criminalize persecution, which is based on gender. What is also important is that apart from that we need to have a very recognizable group, it is important that it also includes intentional and severe deprivation of fundamental rights against individuals or groups because of this construed gender roles, expectations, or norms. So the elements which are important are intentional and severe deprivation of fundamental rights. And in other way, it means punishing, oppressing, or controlling people because they're women, men, girls, boys, or conform to gender norms in that way. So what would be the examples that are discussed in literature? What can be considered to be gender persecution? Just to remind you that within the human rights law course, we will speak about the refugee law. And there you will see that basically gender persecution can be a very good ground for acknowledging or recognizing the status of refugee in asylum claims. But what we see from some cases that we have so far, and also from scholar work, is that banning women from education or employment can be an example. Then punishing men who refuse forced conscription, attacks on LGBTQ plus persons because they violate gender norms, forced dress codes or mobility restrictions, or systemic sexual violence designed to enforce gender hierarchy. So all of these are examples, but usually we speak about a very specific, a very concrete, severe human rights violations with consequences such as ban of education or ban of employment, and usually doesn't go with employment in general for all areas of life. It can, for example, be employment such as medicine, legal, and whatever. So it's not so usually we can debate whether a total ban of employment for women can be considered to be only persecution. What is also important is that I mentioned to you that we have this statute is accompanied by elements of crimes, and in these elements of crimes we have consideration of what can be considered to be a gender persecution. And I mentioned that the element which is extremely important is to have severe deprivation of fundamental rights. These are all rights which are basically enshrined in international human rights law, and it can be, of course, right to life, liberty and security, equality, bodily autonomy, the right to education that we just mentioned, the right to employment, and so on. What is also important, and we said that it's a very crucial element for gender persecution, that we have an identifiable group which is based on gender. But then also to have gender persecution, to show the systemic violation, we need to have widespread and systemic attack, which means that we don't have one isolated incident. Of course, it can be, for example, enough when we speak about the asylum claims. If, for example, someone was exposed to some isolated incident, then that person can claim personal fear. But when we speak about gender persecution from the perspective of international criminal law, then it cannot be an isolated incident, and it has to be done within a larger context of violence against civilians. Another element which is important is the knowledge of the attack, which means that someone who is especially when we have a hierarchy, that the perpetrator know that this is a part of a broader campaign, and usually the one who is hierarchically on the top knows or is aware that it is a part of broader campaign, but either encourages those acts or are not doing everything that is available and possible to in a way react and to protect those who are attacked. And finally, a very important element is discriminatory intent. It is important because here we have specific intention to discriminate on gender grounds. So this is why it is called gender persecution. So basically, the key distinction among other crimes is that we have intention to target a certain group, which is based on specifically, very concretely, on gender. On the other side, as I said, what we have in Afghanistan is of much, we have all these elements as we discussed, but the scale of crimes which are committed in terms of consequences. And when I say it's not very, of course, we have a systemic violence, not an isolated one, but the complexity of everyone which is included here and which encompasses the total erasure of women from public life, basically emerged as a new legal concept, which is discussed by some scholars and also by some international bodies, which they consider that we can find the elements of apartheid as the one that is defined as a racial apartheid, because I'm pretty sure that you are familiar that racial apartheid is related to South African experience. We had, and this is how it was included in a specific convention, but also in the Rome Statute as such. What it says that it refers, this racial apartheid crime, refers to a system of segregation, domination, and institutionalized oppression, which is based on gender and which is often enforced through law, policy, or social order. So basically, we see the complexity. We see more than a gender persecution, which means not done by certain parts, certain individuals, but by government itself. And we have that systemic approach to erase women from public life. So what would be the features of gender apartheid? First of all, it is systematic subjugation or segregation of a gender, which is based on gender. It is enforced by state practices, which has also the elements of institutionalized control of one gender over another. It is comparable to racial apartheid in structure, because usually it is claimed that racial apartheid is a part of colonialism. And we don't have colonialism here in this case, but we have that it is a structural issue here, much more than either when we have a systemic approach, it's not so, let's say, widespread as in this case. But it is not a standalone crime in the Rome Statute, and as I said, it is explained to Afghanistan. There is another country which is sometimes even called to commit gender apartheid, and this is Iran. There is still a difference between Iran and Afghanistan in terms of that complexity and also the consequences of absolutely total erasure of women and girls from public life. So what would be the key differences between gender persecution and gender apartheid? Apart from what was said, that gender persecution is recognized in Rome Statute, and gender apartheid is still not recognized, but we have that, let's say, advocacy to include this crime in a draft convention on crimes against humanity, which are at the moment discussed in United Nations. For gender persecution, we have severe deprivation of fundamental rights, while for gender apartheid, we have systemic segregation, domination, and exclusion. For gender persecution, it must prove discriminatory intent, while gender apartheid is built into the structure of the regime system itself. Gender persecution applies during a widespread or systemic attack, while gender apartheid applies in a system or regime which is designed for oppression. And gender persecution can target any gender, while gender apartheid usually targets women or gender minorities. And also for gender persecution, this is case-by-case acts which prove liability, while gender apartheid is a state-like systems which create liability. So although we have individuals who, of course, can be prosecuted for individual crimes, we have to recognize that this reality goes far beyond gender persecution, and it is also a state-like system which creates such heinous violations of human rights. When it comes to men and boys as victims, we already seen in a documentary, but also we mentioned that last time that men and boys can also face different perspective in terms of their inclusion or their participation in armed conflicts, but also they can face detention and torture and forced recruitment for the reason because that they are men and boys. And we also seen that many of them can experience sexual violence, but we have to say that even if a case is when victims are women and girls, the reporting is not so equal to the experience itself. But for men and boys, it's even more visible that those cases are underreported, and usual reasons for that are stigma, shame, and lack of recognition. Although, of course, these are the same stigma and shame can also be the same reasons for women and girls not to report. And when we say lack of recognition, it means that sometimes national bodies or international community do not have a clear awareness that they can also be victims of this violence. But at the same time, for women, nowadays it's not so much the lack of recognition, like maybe mistrust in institutions to report the case. And it is extremely important that we have this gender lens not only for women and girls, but also to men and boys to reveal these hidden harms that sometimes we are not aware of. And also, another issue, which is a very gender sensitive, are women as perpetrators. And it's also important that women can also be perpetrators of international crimes. They can be guards, commanders, participants in militias. So they can perform different roles especially in armed conflicts. And sometimes the challenge with ICL is that due to stereotypes and prejudices, they are recognized exclusively as victims and not as perpetrators, although researchers shows that they are much less present as perpetrators than from men and boys. And it is also important that this perspective is recognized. I told you that one important point, apart from having the definition and inclusion of elements with gender perspective into the statutes, criminal statutes itself, it is also important that evidence and procedural challenges are usually also very much present. And what we witnessed from all these cases that we have so far is that survivors may avoid testifying due to trauma or shame. And you've seen in this film concerning the Rwanda that we had 3 women who testified among many women who were exposed to these crimes. So they usually will not consider themselves able or maybe just willing to testify. It is also important that physical evidence in many cases is destroyed or just non-existent, and that investigators, so those who investigate the crime, may lack training in gender-sensitive methods, which is also something that we need to be aware of. But what is good, and that was Una's intervention, ICC prioritizes survivor-centered procedures and confidential testimony, and it's very important that that part is present, and that ICC has its kind of approach. When it comes to the institutional mechanisms which are important, I refer here to one important document which is called Policy on Sexual and Gender-Based Crime, adopted some 11 years ago. And this document is very important because it is dedicated to the prosecutor's office. And here it is underlined, and training, survivor protection, and proactive investigations are crucial when we have sexual and gender-based crimes. And this policy is extremely important because this is the first ever comprehensive policy which was adopted by any international court, which in that very sensitive way addresses sexual and gender-based crimes. And what's important is that we also have, when we speak about the institutional mechanisms itself, not only the document under which this policy is guided, we have victims and witnesses unit within the office itself, and also the reparation system, which ensures that gender-sensitive approach is basically based on full, meaningful participation of survivors, and also provide support for victims, and especially for those who are testifying. This policy paper gives a very important strategic and operational guidance to the prosecutor's office on different elements, such as how to investigate the case, how to prosecute, how to interpret in a way what they've seen on the ground, and also what they collected as evidence, and how to present those evidences. And what is extremely important is that the goal of the paper is to ensure consistent, professional, proactive, and survivor-centered treatment in these cases. Why this policy was needed? I think that for you who are here, it's not important to repeat, but I will just briefly mention that what we know is that historically sexual and gender-based violence crimes were underreported. They were also under-investigated. I mentioned the development, but for such a long time, they were not in the focus of international community. They were often dismissed, even in cases when they were reported, or even when we had evidences, they were dismissed as irrelevant. Also, victims, until this moment, they received little protection or support, and that was also one of the reasons why many of them didn't want to testify. And also legal definitions, we've seen that development in legal definitions with 2 ad hoc tribunals, and then in ICC, they were at the beginning narrow or inconsistent, and this is why now we even have this practice to which also interprets these elements. And what is important is that gender justice today becomes really central to the prosecutor's work, and this is why we have and we expect more and more cases on sexual and gender-based violence. Maybe just to finalize our talk on sexual and gender-based violence, just to repeat and maybe to be clear, what are the crimes which it includes? It includes sexual slavery, forced prostitution, forced pregnancy, enforced sterilization, forced marriage, trafficking, especially when it's linked to armed conflict, so as a war crime. We are not speaking about trafficking during the peace, and for trafficking, then we have some other conventions which relate to it. gender persecution that we discussed, and also other forms of sexual violence that can appear in practice. What are the core principles of the policy is, first of all, non-discrimination, which means that these crimes, although they are primarily oriented towards women and girls, it means that non-discrimination means that also boys and men who are exposed to sexual and gender-based violence can also be prosecuted under the same principles. Then a very important element is that we've seen in what phases it is important to pay attention and to have this sensitive approach. But this gender-sensitive analysis to the case from a very beginning until the end needs to be introduced. Then also one important element is proactive investigation. So not only that you're waiting for witnesses to come to you and to witness, but also to be very proactive in identifying witnesses and then also trying to find the ways to bring them to The Hague. I said also survivor-centered approach. When it says survivor-centered approach, it means to respect dignity of survivors, their safety as a very important element, confidentiality, informed consent, and psychological well-being as a very important core components of survivor-centered approach. And with non-discrimination is connected the recognition of all victims, which means that all of them who went through this experience can be recognized as victims. Victim and witness protection measures also means not only ensuring confidentiality, but also shielding identities if it's necessary. Then not only the protection of survivors itself, but also the protection of family members, which sometimes can be really crucial, and especially if, for example, family members are still in the country of origin, while survivors are outside of country of origin, and some kind of revenge towards the family members. Then a different kind of support, but primarily psychosocial support, coordination with the victims and witnesses unit that we mentioned, and what is the primary overall goal is to prevent re-traumatization and to encourage safe participation of survivors, and especially as we know that in many cases we can have re-traumatization, re-victimization, and this is violation by itself. And why it is considered as a milestone in gender justice, not only that it's adopted globally, so it has a very it global recognition. It is important because it integrates gender across all stages of ICC work. It treats sexual and gender-based violence as central, not as some side issue. It recognizes also intersectional harms by non-discrimination, and that all victims are protected. It also provides a very good model which should be adopted by national authorities, but also by some other international jurisdictions also. It is very much aligned with global goals under the resolution 1325 of the Security Council that we mentioned last time. And also it remains one of the strongest institutional commitments to gender justice in international criminal law. And what would be basically, finally, the key messages that we learned from today's presentation is that the gender shapes how crimes are committed, experienced, and prosecuted. ICL increasingly recognizes different forms of sexual and gender-based crimes. However, we still have some challenges in terms of evidence, stigma, and interpretation. Gender persecution is very important in this area because it's also emerging as a critical area of accountability, which goes beyond sexual violence. And we've seen the elements of gender persecution, but Also, it is important that we have more and more cases related to this issue, but implementation is uneven, and we need more and more cases and more recognition. So this is just a very good beginning, very good start, but we expect progress in this area, and it's also important that gender-sensitive lens strengthens justice and contributes to what we've seen in these films, and this is the truth, to accountability, and basically lasting peace. So this is why it is of extremely importance that they are prosecuted, and also that we stand accountable for those who committed those crimes. So with that, I'll end. And what you have seen in your presentation, there are also some videos that you can, as I said, watch, and especially are interesting those on Afghanistan. So for our other courses, I will not give you a homework for this course, for this class, sorry, because you already had homework for the first class that we worked together, and also you got case study from me, and you have 10 days to finish it. It's not a complicated case study. You have to respond to 4 questions, but it's very much related to what we did so far. So you will not have another homework, but let's say that my recommendation for you is to watch this documentary on Rwandan tribunal and on cases of rape, which happened during Rwandan genocide. And of course, if you want to learn more about these issues, you can always come to me and ask for some additional literature on this. Is there any question, any comment, or maybe any let's say remark, not comment, but maybe some, I don't know, feeling?
Professor, I have a comment.
Mm-hmm.
I have a comment on this lecture, because I think international community take more responsibility in this regard.
Who should take?
That is the basic solution for this case.
I'm so sorry, I can't hear so clearly. So can you just repeat whose responsibility is this?
International
community. Sure, this is.
International community need to take more responsibility in this regard, so it can be possible to take more action, and it will be easy for success.
I agree with you that the international community should be more responsible, but at the same time, the primary responsibility is on national states. So here we speak about the international arena, and we have international crimes, which are important when national authorities are not capable, willing, or able to prosecute for those crimes. So I would say that national and international community should both work more on accountability issues, but absolutely agree with you that international community can do much more. Any other comment? If not, thank you so much for your attention. I'm happy to see all of you present. So it was a rare occasion, and I hope that as we worked online, that it was not hard for you to follow. I'm so sorry that I took some additional 10 minutes to finish this presentation, but I hope that it was in a way at least interesting for you, and that maybe some of you will take some papers, seminar papers, or even master theses which are related to this issue. So thank you so much. Next time you have your class with Professor Radović-Lukić, so it's Maya, on Saturday, and she already sent you an email with information on the next class. I will not see you until the end of this class, and you know that Professor Čučković will examine you, but please come to me, email me, come to my office whenever you wanted to share anything with me for the whole course. And if you have some specific questions for my classes thus far. So apart from that, I'll see you for teaching in January for additional 2 courses, obligatory courses that we have. So good evening. Have a good evening, the rest of the evening, and thank you once again, and see you soon.
Thank you. Thank you so much. It was
Bye.
really interesting.
Thank you. Ciao, laku noć.